You're trying to figure out what your slip and fall case is really worth, but every answer online feels vague or inflated. You've probably heard numbers thrown around 5,000, 20,000, 50,000, all with no actual explanation of how that value is determined. But if you don't understand how adjusters actually calculate value and what quietly destroys it, you risk getting lowballed or ignored. This video breaks down the 7 factors that shape your case's real value, from treatment and lost income to fault, timing, and insurance limits. So know what to document, how to protect your evidence, and what could slash your settlement before you even file a claim. Hi, I'm Mama Justice, a personal injury attorney that's helped countless of clients get the justice they deserved. And if you're asking, how much is my slip and fall injury case worth? What you're really asking is, what is the realistic value of the harm this fall caused? And what are the real chances the insurance company will pay it without a fight? And here's the part most people don't realize until it's too late. Slip and fall cases are not valued like a menu item. There is no standard price for a broken wrist, a torn meniscus, or a back injury. The value comes from the story your evidence proves, the medical timeline, and how you can clearly show the property owner should have prevented what happened. So let's break down this the same way an insurance adjuster and a Mississippi jury will break it down. When you understand these factors, you will have a much better idea of what your case is worth and what could quietly destroy its value. Most slip and fall cases start with medical bills because that's the easiest damage to be seen on paper. Emergency room visit, x-rays, CT scans, orthopedic follow-up, physical therapy, prescriptions, sometimes even injections, sometimes surgery. If you fell at a grocery store in Jackson and went to the ER that night, that immediate treatment matters for 2 reasons. First, it documents the injury close in time to the fall. Second, it creates a clear baseline for your damages. But do not stop thinking at what I have paid so far. A lot of slip and fall injuries get worse as time passes. A back injury can turn into months of therapy. A knee injury can turn into a surgery recommendation. A shoulder injury can become permanent limits on lifting, reaching, or even sleeping comfortably. That future care matters. A case with clear medical plan, a clear diagnosis, and a doctor willing to document future needs can be worth significantly more than a case where treatment is inconsistent and vague. Here's a real-world example. Someone slips on a slick restaurant floor in Gulfport, lands hard, tears a rotator cuff. If they treat right away, follow up with an orthopedist, get imaging, and a complete documented therapy plan, the case value is grounded in real medical proof. If they wait 3 weeks, try to walk it off, only go to an urgent care once, the insurance company will act like it was not serious or like maybe something else caused it. If a doctor tells you you may need more treatment, ask them to note that in your chart. Insurance companies respect paperwork more than promises. The next major value driver is lost income. If your fall caused you to miss work, that is part of your damages, not just your base pay, but any overtime, tips, commissions, and missed opportunities you can document. Now let's go a level deeper, because this is where cases can get bigger. Some injuries do not cost you a few weeks. They cost you your ability to do the work you used to do. If you're on your feet all day, work in a warehouse, climb ladders, drive for a living, or lift patients, a slip and fall can change your entire earning power. Think about a nurse in Hattiesburg who slips in a hospital parking lot and injures her back. They might go back to work, but with restrictions, no lifting, no long shifts, no pushing and pulling. That can force a job change, a cut in hours, or a move into a lower paying job. That long-term reduction is often called lost earning capacity. It can be one of the biggest parts of a case, and it's also one of the hardest things to prove without good documentation. Keep a simple file with pay stubs, missed shift records, and any written restriction from your doctor. The clearer the paper trail, the less room the insurance company has to argue. This is the part people feel the most struggle to explain. Pain and suffering is not just it hurts. It's the way the injury changes your daily life. Can you sleep normally? Can you drive without pain? Can you pick up your child? Can you cook? Clean, attend church, exercise, or do the hobbies that makes you feel like you. And it's not just physical. A serious fall can cause anxiety, embarrassment, and the fear of walking in public places. I've seen people in Biloxi who became terrified of a grocery store after a bad fall. That matters. It's real. Insurance companies love to minimize this category because it's not a neat receipt. They may try to use a quick multiplier, like offering a small amount on top of the bills, but the true value depends on how believable and how well documented your suffering is. For example, if you went to therapy following your treatment plan and your medical records repeatedly mention pain levels, limited range of motion, and disrupted sleep, that helps prove the human impact. If your medical records are silent, your case becomes easier to downplay. Write down the day-to-day impacts while they are happening. Simple notes like, "Missed my kid's game because I couldn't sit comfortably," can help you explain your loss later in a clear, believable way. Now, we have to talk about fault because Mississippi law makes this a direct value issue. Mississippi uses a comparative negligence rule. That means that the insurance company can pin part of the blame on you, your recovery can be reduced. The statute often pointed to here is Mississippi Code annotated 11-715, which says contributory negligence does not bar recovery, but damages are diminished in proportion to the negligence attributed to the injured person. Here's what that looks like in plain English. If a jury believes your case is worth $100,000, but also believes you were 25% at fault, your award can be reduced to $75,000. And in slip and fall cases, the defense playbook is predictable. They will say, "You are not watching where you're going. You were on your cell phone. You ignored a warning cone. You wore unsafe shoes. The hazard was obvious." That last one matters a lot. If the hazard is open and obvious, the defense will argue you should have seen it and avoided it. Even when that argument does not win outright, it can still drag down the settlement value because it creates risk. Evidence can protect you here. Photos of poor lighting, lack of warning signs, or a hazard blending into the floor can counter the "you should have seen it" argument. This is one of the biggest value drivers in a slip and fall case, and it's where many cases rise or fall. A slip and fall is not automatically someone else's fault just because you got hurt on their property. You generally have to prove the property owner was negligent, meaning they created the hazard, they knew about it, or they should have known about it and they failed to fix it or to warn people. So the question becomes, how did that hazard get there and how long was it there? A puddle in a grocery store aisle is a very different case if it was spilled 10 seconds before you walked by versus sitting there for 30 minutes while employees walk past it. This is why incident reports, witnesses' names, and surveillance footage matters so very much. Security video can show whether employees inspected the area. It can show how long a spill existed. It can also show whether a warning sign was there and whether it was placed before or after you fell. And here's the painful truth. Many businesses do not keep video forever. Some systems override it in days or months. Not waiting can cost you the best proof you will ever have. If you can report the fall immediately and ask that an incident report be made, then get the names of the employees who responded. That helps your lawyer track down evidence before it disappears. Even if your injuries are severe, the money has to come from somewhere. In many slip and fall cases, the primary source is liability insurance. A large business may have substantial coverage. A small shop may have a smaller policy. A homeowner's policy might cover a fall at someone's house, but those limits can vary widely. So yes, your damage might be worth a large number based on your medical cost, lost income, and pain, but if the policy limit is lower, that can count where it's realistically collectible unless there are an additional responsible parties or assets. This is why it matters where the fall happened. A fall at a big box store in South Haven is often a different insurance situation than a fall at a private home in Tupelo. Do not assume the only insurance available is the obvious one. Sometimes there are multiple policies, like a property owner policy and a contractor policy for maintenance. You cannot negotiate forever. Mississippi has a deadline to file suit in most cases. A common statute reference for the limitations period in Mississippi is Mississippi Code 15149, which provides a 3-year limitations period for actions where no other period is prescribed. A lot of people hear 3 years and think, oh, I've got plenty of time. But value is not just about the deadline. Value is driven by leverage, and leverage depends on evidence. The longer you wait, the more likely it is that the video is gone, witnesses move, employees change jobs, memories fade, the defense gets room to argue the injury came from something else. So yes, you may still have a case 2 years later, but the case might be harder, and that can lower what the insurance company is willing to pay. Act like evidence expires in weeks, not years. That mindset protects your value. A realistic Mississippi example, let's put this together with a realistic scenario. You slip on spilled liquid in a Jackson grocery store. You fall backward and you injure your wrist. Medical bills, ER visits, imaging cast, ortho follow-ups, therapy, let's say $14,000. Lost wages. 2 weeks off work at $900 a week, that's $1,800. Pain and suffering. You cannot drive comfortably, you cannot sleep well, you miss family events, and therapy is very painful. Depending on the facts, documentation, and how long recovery takes, that category could vary widely. It could be $10,000 or it could be $40,000. It could even be more. Now fault. The store claims you were distracted and assigns you 20% blame. Under Mississippi Code 11715, that kind of percentage can reduce what you recover. Notice how quickly the range changes. This is why honest case valuation is usually a range, not a single number. It depends on proof, not guesses. If you or someone you love has been hurt in a slip and fall, here are the steps that protect your claim. First, get medical care immediately, even if you hope it's a minor injury. 2, take photos of the hazard, the surrounding area, and your injuries. 3, get witness names and phone numbers before people walk away. 4, report the incident and request an incident report. 5, avoid giving a recorded statement until you understand what you are saying and why it matters. None of this is about being dramatic. It's about building a clean timeline and locking in evidence before it disappears. So how much is your slip and fall case worth in Mississippi? It depends on your medical treatment, your missed work, your pain and life impact, fault, proof that the property owner was in fact negligent, and the insurance coverage available. And it depends on how fast you move while the evidence is still there. If you want the next step after this, watch the next video. 5 questions insurance adjusters don't want you to ask. Those questions can change the entire negotiation, especially when you're getting pressured into a quick low offer. Protect yourself. Protect your timeline, and do not let the insurance company set the rules of a process that affects your health and your future. See you over there.